Mr. Turner, you're now recognized.
Thank you, Chairwoman Hertha-Sandlin and Chairman Boozman. As a former member of the committee, I certainly am aware of your great leadership on the issue of veterans, and I thank both of you for your service and dedication. And I also appreciate your consideration of this important Bill 4469. H.R. 4469 will amend the Service Members Civil Relief Act to protect the custody arrangements of service members during their deployment, as well as prohibit the use of deployment as a factor in determining the best interest of a child in custody cases. Madam Chair, the stories are too clear and all too frequent. A service member, many times a single mom, is called to serve her country and is given a short time to wind down her personal business and deploy. She makes temporary custody arrangements for her children, usually with her ex-spouse, sometimes in the form of a non-binding family care plan. Then upon return from deployment, and she goes to pick up her child, finds out that the ex-spouse won't relinquish custody without a court order. Sometimes the story is even worse. A service member, in fighting for custody in court, has their custody rights terminated by a judge simply because of deployment or even the possibility of deployment. Deployed parents serving our country in places like Afghanistan or Iraq need protections from courts disrupting these established family arrangements. We cannot have one branch of government asking American men and women to serve while another branch of government punishes them for their service. In the absence of consistent guidance, some states have become aware of this issue and some have taken action. In 2005, the state of Michigan passed a law to provide protection provisions to military personnel similar to the language introduced in this bill. I commend those states who have taken action on this issue. However, almost half of all states have not passed protections for military parents, and for states that have, their protections vary, even if they exist at all. A national standard is required. This is why I have introduced H.R. 4469 to amend the SCRA to provide custody protections for military parents. Madam Chair, our men and women serve in a federal military that is regulated by the federal government. These men and women sometimes reside in one state, but are stationed in another state, have marriage license from one state, and are divorced in another. Disputing custody arrangements should not be an opportunity to shop for the best forum to take a child away from a military parent. H.R. 4469 has passed the House on 4 separate occasions, 3 times as part of the National Defense Authorization Act and once as a standalone bill. As a standalone bill, this legislation was passed by virtue of a voice vote on suspension with support from the chairman of this committee. Additionally, every single member of the House Armed Services Committee, both Democrat and Republican, have expressed their support of this legislation. Through the years, I've tried to resolve any concerns with the legislation and have inserted language that prohibits a federal right of action for custody cases and expressly allows states to create an even higher standard of protection for service members. Much is asked of our service members, and mobilization can disrupt and strain relationships at home. The basic protection is needed to provide them peace of mind that the courts will not undermine judicial proceedings concerning their established custody rights while they are serving valiantly in contingency operations. Every one of these stories is one too many and is justification for taking action. A parent's service to their country should not be used as a weapon against them. This amendment protects them and protects their children. Again, I want to thank our chair and ranking member, and with your consent, I would like to introduce into the record support letters that we have when the bill has previously moved through the House, and also a law review article that goes through the issues that I think most affect the subject matter of this bill.
Hearing no objection, so entered. Thank you, Mr. Turner.